So guys, Nnamdi Kanu is finally winning. And as we all know, the US have been fully involved in the case regarding Nnamdi Kanu and the federal government in the federal high courts. Let's not forget that in the last Nnamdi Kanu's trial, the US sent some observers to come and observe what's happening in the courts and also observe the proceedings that was happening in that very courts. And if you can remember clearly, after the appearance of the US observers sent by the US, the judge, Justice Omotosho, postponed that very case until 18th of July, which is next month. Now, the question is, why was it that it was when the US observers came that they postponed the case by 1 month? Well, I'll be showing you some 6 rebuttals the IPOB released today. But before heading straight to what the IPOB has released and debunked, let's show you what the group had to say about the US observers that was sent to courts by the United States. Now, when asked, this was the reply group gave. The US government likely knew about the American observers at Nnamdi Kanu's trial on June 18, 2025. Reports confirmed 2 US officials were present at the Federal High Court in Abuja, suggesting official involvement, possibly coordinated through the US Embassy. However, no direct statement from the US State Department confirms this, leaving some uncertainty. The presence of these officials reflects global interest in Kanu's case, but it could also raise concerns about foreign interference in Nigerian affairs. That particular line clearly tells you that Nnamdi Kanu's trial is now heading to an international level because the US are ready to do whatever it takes to make sure Nnamdi Kanu is out. And let's not also forget that Nnamdi Kanu is a US citizen and also has a British passport, making him a British citizen too. Let's head to what the IPOB released because the federal government have been using Nnamdi Kanu ever since he has been in detention. They have been trying him for a case that is null and void, and they have been trying him for things that are non-existent. And now the IPOB released 6 factual things to debunk everything that has been leveled against Nnamdi Kanu. Stay put as we walk through these particular 6 rebuttals that have been released by IPOB today. Number 1, Kanu incited violence during NSAS. This was one of the things that was leveled against Nnamdi Kanu, and the IPOB's facts states, no charge before the courts links Nnamdi Kanu to the NSAS protests. The Lagos State Judicial Panel of Inquiry on the NSAS violence did not indict Kanu or IPOB. It instead placed liability on Nigerian security agencies. The DSS witness who referenced NSAS in courts produced no names, locations, or forensic evidence. 2. Kanu's broadcast caused killings of security agents. Facts. Not a single prosecution witness has presented forensic, testimonial, or documentary evidence linking any broadcast by Kanu to actual violence. No security operatives testified. No causation was proven. Allegations were built on Google downloads and edited videos, which were struck out or discredited in courts. 3. IPOB is a terrorist group and its membership is criminal. And the fact IPOB stated was, on the 1st of March 2017, in suit number FHC/ABJ/CS/871/2015, Justice Binta Nyako ruled that IPOB is not an unlawful society. That decision remains valid and unchallenged. The expert prescription order relied upon by the prosecution was obtained without IPOB's presence in violation of the right to fair hearing under Section 36 of the Constitution. 4. Kanu imported a transmitter to wage war against Nigeria. And the fact IPOB stated was that the transmitter was imported in 2015, 6 years before his rendition and well before any allegation of armed activity. There is no proof of concealment, no bill of lading, and no customs or embassy licensing breach presented. The court itself amended the charge unlawfully, failing to endorse the change under Section 218 of 2 of the ACJA. 5. Kanu has a case to answer under Nigerian terrorism law, and the fact IPOB stated was that all terrorism charges were filed under the Terrorism Prevention Act 2013, which was repealed in 2022. Prosecution began de novo in 2023. The Supreme Court judgment reinstating charges in December 2023 was based on the erroneous belief that the repealed law was still in force. Trial under a dead law is unconstitutional, and they referenced Olafisoye v.FRN 2004. 6. Nnamdi Kanu voluntarily returned to Nigeria to face justice. And the fact IPOB stated was that Kanu, which we all know, was abducted in Kenya, subjected to torture and illegal detention, and flown into Nigeria without extradition proceedings. This is a textbook case of extraordinary rendition. Nigerian and international law demand that where the process of transfer is unlawful, trial cannot proceed. And they referenced Diko v. States 1984. Well, these were the 6 rebuttals the IPOB released today, challenging the federal government. And the highlight of everything was that they said that Nnamdi Kanu has no case to answer. But Bola Tinubu, led by the federal government under Justice Omotosho, are claiming that Nnamdi Kanu must answer a case in the federal high courts. Well, at this point, we pray for the release of Nnamdi Kanu, and with the intervention of the US, Nnamdi Kanu is winning, and Nnamdi Kanu is coming out. Biafra is all we need. Do well to like this video, share this video, and hit the subscribe button below for more trending updates.